Bismillahirrahmanirrahim. My dear brothers and sisters, this is the part 2 of the video lecture on subjects of international law. Now in part 1 I was discussing about the 3 characteristics of statehood. The third one is government. So to be a state, there must be a government. And the type of government doesn't matter. It can be a democratic state, it can be a monarchy, a constitutional monarchy, it can be even a military regime. But the most important thing under international law is that the government must be effective. We call effective government. And must be effective within the defined territory and exercise control over the permanent population. Now you can see the linkage between the 3 characteristics: territory, population, people, and the government. This government must be effective within the defined territory and can exercise control over the people of the territory. So that's why just mere existence of a government is not suffice. So this government must have effective control over the territory and the people. So this is important. So we have a leading case on this point: effective government. Effective government. The case is Åland Island case. Åland Island case. So the main issue here is the date on which Finland became a state. Finland declared its independence on December 4, 1917. But at that time, there was opposition within Finland, and the government of Finland, is a new state, was unable to maintain law and order, and can maintain order only with the help of foreign troops, Soviet troops. So that's why the tribunal decided that the exact date Finland became a state was when the Finnish authorities had effective control over its territory without the assistance of foreign troops. And it was in May 1918. Even though it declared independence in December 1917, at that time it was not yet a state. Only when the government of Finland, the Finnish authority, had effective control over the territory, that is, only in May 1918, in law, under international law, Finland has become a state. Okay, so this is the importance of the effective government, or effective control of the government over the people and the territory. Now the fourth characteristics: capacity to enter into relations with other states. So this is known as independence. Independence in law from the authority of other states, or also known as sovereignty. So the writers like Professor Oppenheim, they say that this sovereignty is the fourth characteristic. Sovereignty. Same meaning. Independence, external independence. No other state has authority over that country, mean external independence or external sovereignty. So capacity to enter into relation. A state can enter into relation with other state without any interference or without any intervention by other states. Freely can do whatever it likes with other states. So this is the capacity to enter into relations with other states. And the leading case on this point is Austro-German Customs Union case. Between Austria and Germany, they reached an agreement on a customs union to establish a free trade between the two countries. And the issue was whether this agreement, treaty to establish free trade, affect the independence or sovereignty of the state. So this is a very famous judgment made by Judge Anzilotti, Permanent Court of International Justice, PCIJ. Austro-German Customs Union case, PCIJ. So this is the quotation from the judgment. Independence, that's why I told you that the two are the same. Independence may also be described as sovereignty. Independence and sovereignty are synonymous. Meaning that, what is the meaning of that? The state has over it no other authority than that of international law. So that's why you see, a state is a sovereign state. This sovereignty means the authority. supreme authority above which there is no other higher authority apart from international law. Okay, so that's why other states cannot interfere. A state can do freely anything it likes, but it is subject to international law. This is so. Those who do not understand international law very well, that's why the politicians are arguing about whether we enter a treaty, whether it can affect our sovereignty. It's a very, bad idea. Bad idea here means ignorance of international law, ignorance of what is international law. So the ignorance of the essence of international law. So international law is the law that is above. Okay, states, okay, even though they make international on the basis of their own free will consent, once they make international law, they are subject to international. That's why we call the term subject of international law. Why we use the term subject? States are subject to international law. We are subject to our national law. Yeah, right? We are subject to our national. So also states are subject to international law. So that's why freedom or independence or sovereignty here means the state has over it no other authority than that of international law. So then, therefore, there can be restrictions. There can be restrictions upon a state liberty by means of a treaty or otherwise customary international law. These are the restrictions. The states themselves agree to treaties. They themselves agree to customary international law. And these restrictions do not, as such, in the least, affect its independence or its sovereignty. That's why entering into a treaty, does it affect sovereignty? Not at all. Because a state enters into a treaty with its own free consent, with its own free will. Okay. Based on consent. This is a contract. Treaty is a contract based on consent. You make a treaty with your consent. Then you are bound by that because of your consent. Okay? So that's why once you have made a treaty, you enter into the treaty, this treaty is binding on you. It doesn't mean that your sovereignty is, or the sovereignty of the state is affected. No, not at all. Because you are exercising your sovereign right. Or what I mean is that a state is exercising its own sovereign right to enter into a treaty. Okay, so that's why the third paragraph says that as long as these restrictions do not place the state under the legal authority of another state. So when we talk about independence or sovereignty, we're talking about with other states, compare with other states. So no other state must have control over us. America must have a control over us. China must have a control over us. Then we have no sovereignty. We are not independent. Under the British, we are not independent. Why? Because Britain is controlling us. We are not independent. So, but now we are independent. We are sovereign. But we can be subject to international law by means of treaties, enter into treaties, or by means of following customary international law. Okay, so that's why entering into treaty doesn't affect the sovereignty. Okay, as long as it is not under the authority of another state. Okay, the state remains an independent state, however extensive or burdensome those obligations may be. Like Rome Statute, for example. So the obligations may be very burdensome, but however burdensome the obligations may be, you agree and you accept the obligation, then your sovereignty not affected at all. But because you decide yourself and you give your free, with the basis of free will, you enter into the statute. The only thing is that you have to decide whether this Rome Statute is okay or not. This is the only thing. Okay, thank you very much. Next one is federal state. When we talk about state, we have two types of states. Unitary states and federal state. Unitary constitution, federal constitution. So there are many states in the world which are unitary, and there are also states in the world which are federal. So in the case of federal state, the federal government, who has the international legal personality? Which entity has the subject international? The federal government or each and every government of each and every state. So this is the problem. So the international is very clear. The decisive factor is the federal constitution. The constitution is the decisive factor. How the constitution provides. So member states within a federal state may or may not be allowed by the federal constitution freedom to conduct their own foreign affairs. It depends on the federal constitution. Some federal constitution they allow the component states to conduct foreign affairs, to enter into relations with other states, to enter into treaties with other states, even to send diplomats to other states. Then these component states may have international legal personality. But some federal constitutions, they do not allow component states such power to enter into or to conduct foreign affairs. In these federal states, the component states have no capacity to enter relations with other states, and they have no international legal personality. What is the position in Malaysia? Malaysian position in the second category, meaning that according to the Malaysian constitution, you know very well, we have discussed it under the third chapter, relationship chapter. So external affairs is in the federal list, not in the state list. So that's why only the federal state can conduct external affairs. So that's why only the federal state has the international legal personality. Only the federal state is a subject of international, not the component state. Each and every state like Kelantan or Terengganu, they have no international legal personality. They are not subjects of international law, and they have also no treaty-making power to enter into treaty with foreign countries. Now, we have done our part on states as subjects of international law. Now we move on to the second situation, that is about international organizations. Apart from states, international organizations, we mean intergovernmental organizations, can be subjects of international law. Because they are organizations of states, they are established by states themselves, and states themselves give some powers and functions aside to these international organizations. So that's why, depending on how much power or how much function they are assigned, they can enjoy international legal personality. That's why we have to look at the organization, mainly the constituent instrument or the constitution of the organization. How much power is given to the organization by the states? Okay, let us look at first the most important international organization of the time, that is United Nations, whether United Nations have international legal personality or not. It is not expressly stated in the charter. Some treaties, some international organization in their constituent instrument, it is expressly stated international legal personality. But in the case of United Nations, there is no such express provision. So that's why we have to look from the so many other provisions of the charter. By impliedly looking at all these provisions, we can decide whether United Nations possess international personality or not. Okay, now let us look at first privileges and immunities. So now we have to test with the 4 characteristics, right? So whether United Nations can enjoy privileges and immunities under international law. So we can refer to Article 105 of the Charter, the two paragraphs. The first one is, the organization shall enjoy in the territory of each of its members such privileges and immunities as are necessary for the fulfillment of its purposes. Now, very clearly, the Charter says that the United Nations organization, as an organization, this paragraph on as the organization can enjoy privileges and immunities in the territory of each and every member, because United Nations have no state territory. Territory is only for the states. States only have territory. The organizations have no territory. So they are derivative subjects of international law. For example, United Nations has no territory. That's why it has to rely on, even for the headquarters, it has to rely on USA. So the headquarters of UN, where is headquarters of UN? In New York, right? In New York. So to establish this headquarters, UN has to enter into a treaty or agreement with United States of America, headquarters agreement. Okay, so then United States, when UN representatives, UN officials are there, so these UN officials and representatives of states to attend the meetings of the United Nations, they are entitled to privilege and immunity. So that's why when we talk about privilege and immunity, first, the organization itself has privileges and immunities, and secondly, number paragraph 2, representatives of the members of the United Nations and also officials of the organization, similarly, they enjoy privileges and immunity. And then in detail, we'll discuss in the next part. Thank you.